Good afternoon, everyone. We've got a lot to get through this afternoon. Our audience covers a range of experience, but we'll try and cater for you all. The breakdown of our three talks will be as follows. Dr. David Thomson, he's a doctor as well as a barrister, will address the relationship between brain injuries and lack of capacity. I, John Ross, will then go next, dealing with the Court of Protection and the issue of how to assess capacity or loss of capacity. And then the third aspect of today's talks will be delivered by Susanna Bennett, whose talk will cover quantification of damages and investment decisions. There is a questions feed. We will endeavour to deal with these at the end of our three talks and therefore propose to set aside somewhere between 10 and 15 minutes for that purpose. As we have 250 attendees, the system will only work if you turn off your cameras and also your sounds. Delightful though it would be to see you all and to have a live audience. Thank you. David, would you please proceed?
Thank you, sure. I would say we've had some questions in advance as well, and we'll deal with those if we can at the end of this, but we endeavour, even if we don't have time, we'll address all the questions with some email or written response, so nobody feels as if they're left out. Just that with so many participants, there's a good number of questions, and it just takes a bit of time to get through. So, Susanna, next slide, please. Yeah, you've had a look at this is how we're going to shape this brain injury, relationship between brain injury and lack of capacity, and the aspects of that, managing one's own affair and legal proceedings. And then other aspects will be developed. The contentious matters where the courts are involved by Mr. Ross, and then Susanna will deal with the tickling difficult point of how it all brought together in a damages assessment or claim. Next slide, please. So, there's a whole number of different potential insults you can have to your brain. I'm going to focus today on traumatic brain injury because that's the most apposite really for the sort of audience that we have, that are mostly clinical negligence and personal injury practitioners as well. So next slide, please. When you're talking about brain dysfunction, we'll just go through some sort of standard diagnoses or definitions. Any brain dysfunction, no matter cause, causing that could potentially affect a person's ability to understand or cooperate with or perform a range of tasks. So this is what brain dysfunction is about. But in usual terms, people deal with direct trauma. That's either falling off your bicycle, being knocked off your motorbike, or slipping off the garden fence or something similar. And you can have a range of different problems, from direct damage to the brain substance itself, to contusions or bruising, to secondary bleeding in and around your extradural hematomas, your subdural hematomas, subarachnoid hematomas, and intracranial hemorrhages. Many of you will be very familiar with this, so apologies if you've been through this radio before, but there's a number of people that are attending that are reasonably inexperienced on providing a very full view. You can have other insults to the brain that have nothing to do with trauma as such. So you can have hypoxia, low oxygen birth traumas, carbon monoxide poisoning, sepsis, encephalitis. They can produce direct effects with the bacteria inflaming things, or as a secondary effect on one's circulation, relative hypoxia, and other problems that the brain is starved of its vital oxygen, glucose, and other nutrients because of the ongoing general infection. One of the things you want to emphasize is that your body works as best it can to preserve the brain because it's the vital nerve center for the whole thing. The other thing about brains is that their food, as well as oxygen, is glucose. I had a case a while ago, many years ago, where an Irish labourer was given some headache tablets because he had a headache, and they turned out to be metformin, which is a glucose lowering medication, oral medication that people have when they have type 2 diabetes. He went to sleep, his glucose was profound, and he never really woke up again because he'd had a profound period of low glucose overnight, and that had starved his brain of its vital nutrient, which is glucose. He never recovered and is in a persistent vegetative state. This history event's always important, what actually happened in the road traffic collision or the clinical incident. And the other thing that they always say is look at the person and not the scans. So sometimes you have somebody that's profoundly funded, not able to do anything, communicate, and the scan doesn't look bad at all. Another person, you can have part of a fence post jammed in and across one of their hemispheres, and their function is actually pretty good. So always look at the person, not the scans. Next slide, please. So we're focusing on traumatic brain injuries. With traumatic brain injury, the thing to bear in mind is that the different forms of injury can affect different parts of the brain. That seems to be stating the obvious. But the usual one are, just going through it on this third bullet point, parietal lobes, which are the big lobes either side, motor and sensory function. If you damage the right-hand side parietal lobe with direct trauma, hammer or something like that, or a stroke, then you often have effects that manifest on the opposite side, the left-hand side. Other things, frontal lobes, the ones at the front, self-evident, they affect personality, memory and behaviour, loss of insight, self-restraint, not inhibited anymore. People become, as they say in the trade, a bit frontal. Occipital lobes at the back, they're the ones responsible for you interpreting what your eyes are producing and turning them into a visual field for yourself and what you perceive. If you have damage to your occipital lobe, even though your eyes are working, you can end up cortically blind. The effects to consider as far as traumatic brain injury are concerned, looking to capacity, are physical, cognitive and behavioural. Next slide, please. TBI, the definition there. What often is characterised as the TBI, the traumatic brain injury, is whether it's mild, moderate or severe. And those are the definitions. Moderate head injury, loss of consciousness between 15 minutes and 6 hours, or a period of post-traumatic amnesia, so after the event, up to 24. Severe head injury, patient unconscious for longer, 6 hours or more, and a post-traumatic amnesia is longer. Mild head injury is less than the above. There's lots of argument about what exactly is a mild head injury, but essentially, in my view, it's something that's not moderate or severe. Next slide, please. The other thing you pick up in the expert reports, clinical records or whatever, is a clinical assessment tool. This is a Glasgow Coma scale. And this is a scale where you examine people and seek responses, both eye and movements, and you characterise it as a number of points out of 15. And in general terms, if you've got a Glasgow Coma scale, a GCS of 13 to 15, near normal, it's a mild TBI. And then as the points deteriorate, it indicates moderate, severe, and then if it's permanently very low, then you're either in a persistent vegetative state or something similar. The thing to remember is the GCS can fluctuate, so it can get better or worse. The alarming thing is when it's getting worse, when it started off not too bad at 13 to 15, and it gradually deteriorates. The point about that is that something is going on, and you have to look a bit harder. Next slide, please. Clinical assessments. This is what you, as your solicitor, you're looking at the papers, you're looking at what you first got, you've looked at the GP records, what else is happening about this person. There may be a social worker's comment, but you have to look at competent clinical assessments. So that's motor deficits, perceptual sensory deficits, vision problems, communication and language deficits. And you have to, and we'll get around to the bit about the expert evidence in due course, but it's important that the competent clinical assessments are looked at and you look at these with a weather eye. I've set out all the different possible deficits you can get with some of the Latin names, which are just ideal for pub quizzes and Scrabble. The one that comes up again and again is the nystagmus. Everybody bandies that around, and that's just jerky eye movements, and that indicates that something likely is going on in the more central part of the brain, the midbrain and brainstem. Other difficulties that are looking at the speech, that's the obvious thing, difficulty speaking or difficulty finding the right words. Next slide, please. So you're gradually building up a picture of this person, cognitive defects, the functional defects, the social difficulties, and the regulatory disturbances are very important, especially over the long term. Fatigue, changes in sleep, eating habits, dizziness, headache, loss of bowel and bladder control. And then personality and psychiatric changes. These are often insidious. The particularly destructive ones are where people are depressed or emotionally labile, very destructive for the family. Next slide, please. It may well be that you're the first person to suspect that there is something wrong with the capacity. A lot of people just muddle and make do. And when you, as the lawyer seeing this person for the first time, have a weather and a careful look at whether they have capacity. Because you're the person that's got this person in front of you. You may not be a medical expert, as we'll see in due course. You should be in a position to form an initial view and if any doubt, act upon that. In due course, you'll need to look at the information that's available, history, events, whatever it might be, the road traffic event, clinical records, local authority, DWP records, etc., and then look to instruct different experts that will assist you with the phases of the assessment. The neurologist will be looking at examining and the full history. CT and MRI scanning, those scans are improving. It may well be that they want an EEG, an electroencephalogram, looking at the activity within the brain in different areas. That can be done either neurologist or more frequently nowadays by a neurophysiologist, a specialist person that does that sort of work. Then we get the neuropsychologist, neuropsychiatrist, and possibly the neurosurgeons. Neurosurgeons tend to be involved more in cases to do with trauma or growth or a tumour in the brain causing cognitive problems, etc. And then after that, the next phase is about rehabilitation, disability, and other such matters such as accommodation that Susanna will consider briefly in due course. Next slide, please. So if there's traumatic brain injury or some brain injury, and you think that there may be an effect upon capacity, the principles have to be applied under the Mental Capacity Act 2005, actually came into force in 2007 with the Code of Practice. And it sets out the principles in section 1. Person must be assumed to have a capacity or have capacity unless it's established he lacks capacity, not treated as unable to make a decision unless all practical steps to help him or her have been taken without success, not treated as unable to make a decision merely because makes an unwise decision, and any act or decision made must be done in his or her best interests. So before anything is done or any decision made on their behalf, regard must be had for the purpose of which it's needed, and can it be achieved in a way that is less restrictive of the person's rights and freedoms of action. Next slide. This is just a summary. There are 5 principles: presumption of capacity, support to make a decision or practical steps taken, ability to make unwise decisions, best interests, and the least restrictive approach. Of course, 4 and 5 only apply when the person's been assessed not to have mental capacity for the decision in question, the particular matter that's being considered. And it's that decision and at that time. And it's not the actual decision what's being decided, but the context that it's seen within, how it's arrived at, how it's made by that person. So it's time and decision specific, never forget that. Just to mention that there's no absolute definition of best interest. Seems fairly obvious. Section 4 goes through a procedure of how to make a determination of best interest, but it's not defined anywhere, so don't look for it. Next slide, please. Some of the indicators that are often seen: lacking a general understanding of the decision that needs to be made, why it needs to be made, lacking a general understanding of the likely consequences of making or not making the decision, unable to understand, remember, and use the information provided when making or thinking about making that decision, and being unable to consistently communicate the decision or what the decision is intended to be. Also, with a further gloss on what we talked about, the general principles, if somebody repeatedly makes unwise decisions that might put them at risk of harm or abuse or exploitation, that's a matter of concern and may, as a whole process of behaviour, indicate a lack of capacity. And if the decision that's made is irrational or completely out of character, that's a warning sign the bells should be ringing. Especially if somebody seems to have what seems to be a disturbance of the functioning of the mind or the brain. Next slide, please. Who's making them? Like I said, the decision is time and decision specific about the assessments. So it should be the person involved in supporting the person making the decision at the time, or the formal responsibility of making a decision if the person's unable to do so. So I've given some examples. There's many one could dig out, but there are different sorts. Carer, support worker, decision what to bath or eat or what they want to do. Nurse, capacity to dressing change or have any form of treatment. GP, capacity to take the medication. Do they understand and do they know why? A consultant about consent to surgery, for example, consultant surgeon. Social worker, decision where they want to reside or live. Legal matter, first instance, solicitor or legal practitioner should assess capacity. Now, some people might say, assessing capacity, really? But this is just decision-specific matter. Who's there and who's the person that is assessing capacity? The judge might decide to appoint a deputy to manage capacity and manage financial affairs if it's concerned about financial capacity, as we'll see in due course. Next slide, please. So a number of people will be sitting there going, oh, bloody hell, I've got to be assessing the capacity of my clients. Well, my view is that you ought to at least have that run through your mind whenever you meet any new client, because the effects of somebody not having capacity and you not having thought about this or raised it can be quite significant, in the sense a number of steps can be null and void, as we'll see in due course. So if it's possible, or even probable, but possible, presence of impairment or disturbance in functioning of the mind or brain, this is the stage 1, the diagnostic test, then consider capacity and what to do. Now, sometimes it could be temporary or permanent. I mean, somebody could be drunk. We've all had clients or people at court that are a bit late, and they've obviously had a few sherries that time in the morning and a bit incomprehensible. I suppose if you leave them for a while, they may well improve in their capacity to make decisions or give evidence. But that's situation specific, and we've all had it. So you've got to think, is this temporary or permanent? If it's temporary, then I'll see you tomorrow when you've stayed off the sherry in the morning. Maybe some people can't because they're a chronic alcoholic. Stage 2 is the functional test. Once you've made the diagnosis that somebody might lack capacity or probably lacks capacity, the next thing is, well, okay, if they do, what about the capacity to make that particular decision? And this is the functional test. It's actually making the decisions. Next slide, please. And unable to make the decision, this is the functional test. Is he able to retain the information, use or weigh up the information, communicate the decision? Now, if the person lacks capacity in these areas, where you believe they do, then what to do? Well, we'll see in a minute. We'll have to decide about whether somebody's better placed to provide an opinion on the capacity, the diagnosis, i.e. a neuropsychiatrist or a medical expert. Or even if it's stage 2, but you think somebody might have, but the point is really, is it such is that the function, they're not able to make the decision, or actually whatever impairment they've got is such that they can make the decision in all the circumstances at that time. And it may well be the prudent thing to do is share that experience, share the conundrum with somebody else in the office, one of your partners or counsel. It shouldn't be made in isolation. People shouldn't be feared of moving along this process. And the MCA isn't a complete code, as we'll see in a moment. The CPR affects other matters as well. One point as well, and it's in the code of practice for the Mental Capacity Act, make a good record, a detailed file note, and in that record your decision, if you thought about capacity and what you decided in that stage 1 and stage 2. It's prudent just to get into that habit. It'll only take a paragraph, but it's a good thing to do. Next slide, please. And we'll just promptly go through these. These are the different provisions in the CPR. Part 21, children protected parties. 21.1 describes the scope of it and provides some definition. Child means a person under 18. Lacks capacity means lacking capacity under the Act that we've just been through. And a protected party means a party, intended party, who lacks capacity to conduct proceedings. A perfected beneficiary lacks capacity to manage and control money, so somebody's going to get some money but isn't actually necessarily conducting the proceedings. Next slide, please. Stage of proceedings, litigation friend. This is for somebody that lacks capacity and that a litigation friend should be appointed. The other thing to remember is that a claimant may issue and serve a claim form against a child or protected party who doesn't have a litigation friend. However, no further steps may be taken without the permission of court until a litigation friend has been appointed. And there's a conundrum sometimes about whether to appoint a litigation friend or not. And the case of Bradbury looks at a particular exceptional case. But in general terms, a litigation friend has to be appointed for any further steps to be taken. Next slide, please. That again looks at it, depends on the circumstances. Hinduja sets out a particular case where the starting point was that a litigation friend wasn't necessary. You can look at that case, it's interesting, but these cases all turn on their particular facts. There can be consequences as well. Beware that if there's a squabble going on between potential litigation friends or between the litigation friends and family, it may well be that the litigation friend is a member of the family, then there's a possibility that the defendants may say, well, this argument, these further applications are going to be at your cost, not ours, and the only cost that the defendants ought to be paying is the base cost of the application. So beware, there can be cost consequences. Next slide, please. These are just some useful forms, just a memoir for the ones that you're always thinking, which form do I have to do? These are the ones for these particular circumstances that are relevant to this. Next slide, please. Practice Direction 21, not just the CPR part of 21, but the Practice Direction 21 is very detailed. Detail in that is mostly relevant to financial settlements and other such things. The usual one is 10.2, where there's a beneficiary of more than 50,000 and the steps to be taken under that. But I won't go any further on this because Susanna's going to deal with this in due course. Next slide, please. These are some other forms that just, when you're looking at the finances and the damages in those hearings, but consider anonymity and prohibition of publication order if it's a child or even a protected person, and the other ones that are there that you have to use. There's a big emphasis at the moment, use the forms, don't do anything bespoke. Those are the ones, they're not all of them, but they're the ones that are most relevant. Next slide, please. Just some cases hot off the press. I won't go through these in any detail because time's moving on. Northern Khan is to do with expert evidence for somebody that's had a neurological injury and arguments whether a neuroradiologist is required or not. And that indicates that courts are prepared to listen to arguments and decide which experts are required as far as capacity is concerned. Just to do an interesting case where a woman who has a psychotic illness was pregnant, and an advance declaration was obtained by the court that if she were to become psychotic during the labour and delivery, that steps could be taken when she'd lost that capacity. So it's getting an advance directive because there was a real risk of that happening during the labour. And Shirazi is a complete bun fight. Mrs. Shirazi, the wife of a person who's under a disability, she was a litigation friend, and the two sons are arguing about whether she's got capacity or not. The youngest son supposedly had some undue influence. It's interesting and it's worth a read about just how things can go badly wrong. In the end, even though she was an elderly lady, the court decided that she did have capacity to manage the financial affairs and to be a litigation friend. Next slide, please. And it's on to Mr. Ross.
Thank you, David. I am going to take you through a quick overview of the Court of Protection and what it does, and then go straight into the issue of capacity, that is litigation capacity and property and affairs capacity. I'll be looking at the statutory provisions and the cases in which the courts have further analysed and defined the applicable test. The word trilogy will appear because there is a set of 3 Court of Appeal cases, now of some vintage, which you will need to know about. They are Masterman Lister, next Dunhill and Bergin, which ultimately found its way to the Supreme Court as well, and Bailey and Warren. The discussions in those judgments are useful, but only up to a point. And so I also propose to take you to 3 recent first instance decisions. 2 of them are the Court of Protection, 1 of the Queen's Bench Division, which show you in a more practical way how the courts are now deciding this issue of capacity. And those 3 cases we'll deal with at the end, but just for your note, they are called TB against KB, 2019 decision, King and Wright Roofing, a 2020 decision, and an NHS Trust and P, which is a decision of last year. Right. As you can see from this slide, the Mental Capacity Act 2005 created a specialist court, which is called the Court of Protection, whose core tasks are to deal with 5 issues. To determine whether a person has mental capacity to make specific decisions. Next, where a person does lack capacity to make the decision on their behalf and in their best interests, or to appoint a deputy to do that. Next, to make declarations as to the lawfulness of acts that have been done or are to be done in relation to a particular person. Next, to determine questions in respect of lasting and enduring powers of attorney and advance decisions to refuse medical treatment. And since the 1st of April 2009, also to hear challenges against so-called deprivation of liberty safeguards, authorizations, otherwise known as DOLs. What I need to tell you is that most of its work is non-contested, and the statistics, as this slide indicates, suggest that 95% of all applications before the Court of Protection would fall into the category of uncontentious and cases, therefore, which can be determined without a hearing. Next slide, please. These are the starting points, the sections which you will need to read. I don't propose to go through them now because we don't have time to do so, but there is a record of what it is that you need to read in this connection. Next slide, please. As you know, the law of capacity derives from the Mental Capacity Act 2005 and also from the judicial interpretation that has followed on since that act was passed. Next slide, please. Issues concerning capacity arise in a range of situations. They cover welfare decisions, financial decisions, and litigation decisions. A person may have capacity in relation to many of the day-to-day activities of life, including managing small household budgets, but yet not have capacity to manage large or complex decisions. Those might include the management and investment of a large sum of money that must be maintained in order to support that person for the rest of his or her life. That could be money that's been accumulated over the working years of the individual, or it could be a damages award resulting from a traumatic brain injury claim. Next slide, please. So the Act sets out the statutory test for assessing capacity. First of all, there is a diagnostic element, and there is, secondly, a functional element. The diagnostic element concerns the individual's inability to make a decision, and that must be caused by a temporary or permanent impairment of or disturbance in the functioning of the mind or brain. And that's where your medical evidence will come into play. Secondly, there's a functional element. The functional test should be considered in detail because it deals with the decision-making process of the individual as a whole. And as you might imagine, parties, if they're involved in litigation, claimants and defendants experts can disagree quite significantly on these issues. So let's move to the next slide, please, which tells you in a summary way what the law on mental capacity is. So Mr. Justice Parker, Laughlin and Singh, 2013. It says Section 2 provides for the purposes of this Act, a person lacks capacity in relation to a matter if at the material time he's unable to make a decision for himself in relation to the matter because of an impairment of or a disturbance in the functioning of the mind or brain. 2, it does not matter whether the impairment or disturbance is permanent or temporary. Next slide, please, which leads us on to the next section. For the purposes of the section we've just looked at, a person is unable to make a decision for himself if he's unable, A, to understand the information relevant to the decision, unable to retain that information, unable to use or weigh that information as part of the process of making the decision in question, and D, unable to communicate his decision. Next slide, please. The principles to be applied for the purpose of the Act are, as you've just been told by David, a person must be assumed to have capacity unless it's established to the contrary. A person is not to be treated as unable to make a decision unless all practicable steps have been taken to help him to do so and have been taken without success. So, for example, if the person is partially sighted, then outside assistance may enable this to be overcome. Similarly, with somebody who's suffered a mild traumatic brain injury, outside assistance might enable that individual to reach those decisions, albeit be a longer and slower process before the decision can be made. Thirdly, a person is not to be treated as unable to make a decision merely because he makes an unwise decision. So the underlying objective of this act is the laudable one of empowering people who have limited capacity to make as many decisions affecting their own life as they reasonably can be enabled to do so. Next slide, please. As we've indicated already, the capacity issue needs to be determined in respect of both time and decision. The time element focuses on the particular time that the decision has to be made, whereas the decision specific concentrates on the particular matter to which the decision relates, rather than the ability to make decisions generally. Next slide, please. So Dunhill and Bergen is the first of the Court of Appeal decisions. This focused on the claimant's capacity to litigate rather than capacity generally. The claimant had entered into her own negotiations with the defendant, agreed a compromise of her claim as low as £12,500. The court said that the individual should know how to make the decisions that are likely to arise in the litigation, which include giving proper instructions, approving particulars of claim, and notably in this case, the capacity to approve a compromise. In order to approve a compromise, insight is required into the compromise itself, which would include an understanding that their legal representative's advice and an ability to weigh that advice in the balance. Next slide, please. Masterman Lister is the next case. What that established is that litigation down to the administration of the award of damages is to be treated as a single transaction and not as a series of individual steps. That's obviously helpful and important because there might be some decisions along the way towards a compromise that an individual could understand without that individual being able to comprehend the totality of the decisions that need to be taken. So where a claimant was left with a range of difficulties, including lack of motivation, distractibility, irascibility, lack of judgment, disinhibition, poor recall, that's memory recall, lack of concentration and obsession, in this case with his mobile phone, the judge found that the advice he may receive for the purposes of this litigation may be considerably more complex than the relatively straightforward advice that in the view of his condition it would be prudent to place the monies in trust. In addition, it cannot be excluded that he will receive conflicting advice from other persons with whom he may be in contact, advice that would not necessarily be disinterested advice, and he would be unable to weigh the merits of such advice against that of his professional advisors. So that is a first instance decision that provides you with some assistance in this regard. Let's move on to the case of Bailey, which is a decision, no, back slide please, yeah. Ward, Mr. Justice, Lord Justice Ward said in Bailey that at paragraph 178, the client must be able to understand all aspects of these proceedings, taking informed decisions with the help of such explanation as he has been given, which bears upon them. It cannot be judged piecemeal. If he has the ability to understand what is meant by a 50-50 split of liability, but he lacks the capacity to understand the concept of damages which results from that division of liability, then he lacks true capacity to conduct the proceedings. Thank you. Next slide. So the key witnesses, as David has said, are likely to be the medical experts, in particular neuropsychiatrists and neuropsychologists. The neuropsychologists will subject your client to in a traumatic brain injury case to a series of psychometric tests which are now well established to ascertain what deficits of reasoning and thinking processes the individual might suffer from. That, of course, is conducted in the quiet of a consulting room, and so doesn't necessarily reveal all the deficits that an individual, particularly one with a frontal lobe injury, might have in dealing with the ordinary requirements of day-to-day living and interacting with other individuals. The neuropsychiatrist then is likely to be the most important expert for you, because that expert will be dealing with the impact that the brain has had upon his functioning capabilities in the real world. So, working examples of the court's approach, let's have a look at Verlander and Rahman. There was evidence in that case of significant sums being spent on online gambling and other examples of inappropriate expenditure on funds on the smaller items. It was that which enabled the judge to conclude in that case that the claimant was unable to weigh the necessary information as part of the process of decision making. Similarly, in Laughlin and Singh, the brain-injured claimant was found to have lacked capacity to manage his financial affairs, even though he'd undergone intensive rehabilitation and was in receipt of a support worker who gave assistance on everyday living. And that input was little short of 24/7 input. The reason was that the claimant had poor organizational skills and difficulty with motivation and initiation. And that was the basis upon which the judge found that there was a lack of capacity. Next case, please. So Rule 21.4.3 suggests a focus on proceedings in general rather than on the proceedings as framed. So if the claim has been significantly undervalued by the solicitors when it's advanced, the court will look at the true value of the claim in deciding whether or not the individual had capacity to reach, in that case, a settlement of the claim. And this meant capacity to conduct the claim or cause of action, which the claimant in fact has. More particularly, the issue was not capacity to understand and make decisions based upon the actual advice given by, in that case, the negligent lawyer. Please, next slide. Let's move on to the three recent cases that I referred you to, TB and KB. In the first of these, it was litigation concerning the property and affairs of the first respondent, P. P's son applied under the Act for a declaration that he lacked capacity to conduct the litigation. P was aged 75, had long-standing difficulties with alcohol. He had short-term memory loss and impairments to his executive function. He had substantial assets. He had a friend and carer in whose favour he had granted a lasting power of attorney in respect of his property affairs and health and welfare. The son alleged that carer lacked the ability to manage his affairs in his best interests and was motivated by self-interest. He contended that his father, P, did not have capacity to execute the lasting powers of attorney, so he made an application to the court under the Act. And as regards the capacity to conduct litigation, the court said this, which you might find helpful: the nature of legal proceedings and the demands they make on litigants has to be considered. A litigant's role involves a dynamic transactional process with information to be recalled, instructions to be given, advice to be received, and decisions to be taken, potentially on a number of occasions as the proceedings develop. And so you can see what the court is looking at there, the totality of the involvement of the individual in the litigation and that individual's ability to do so. The next case was King and Wright Roofing. This was a case arising out of a fall from a roof and a claim resulting from the claimant. The defendant admitted liability subject to contributory negligence. The accident had caused the claimant to suffer personality change. For a time, he was unable to talk normally. He couldn't work. He ran up debts. He received some interim payments from the defendant, which he promptly lent to acquaintances, and he also spent it on trips to the Dominican Republic because he said the climate eased his pain and lightened his mood. His friends and family were concerned about his capacity, and so they intervened. The claimant became exasperated about the litigation, felt his solicitors and the deputies were dragging things out to make money for themselves, and that was the issue before the court. Now, how did the judge deal with the issue of capacity to conduct proceedings? He said the question was whether the claimant was unable to use or weigh the information relevant to making decisions about his claim. That included information about whether to solicit or accept a settlement offer and what evidence was needed. And he said that the claimant was unwilling to accept advice, unable to think through the consequences of decisions that went beyond merely disagreeing with the way that the claim was being conducted. He could not use and weigh the information about Part 36 offers and the consequences of recovering less than the amount of such an offer, and he had particular difficulty in using and weighing the information about the disadvantages associated with not settling his claim on proper terms. And finally, an NHS trust against P. This case is factually quite unusual. The court had to determine whether a 60-year-old woman, P, had been diagnosed with diabetes, paranoid schizophrenia, and HIV, had litigation capacity. Since 2018, she'd refused to take the antiretroviral medication prescribed to her to treat her HIV. She believed that God had spoken to her and told her not to take the medication. The medical evidence suggested there was a 50% probability she'd die within a year if she continued to refuse her medication. The trust then intervened and sought orders and declarations that she lacked capacity to decide whether to take that medication and that it was in her best interest to do so, and inferentially that she should be made to do so. That raised the litigation capacity issue. Now, this I think is helpful to you in practical terms, because the way the judge approached it was this. When judging a person's capacity to conduct litigation, the question was whether the person could conduct the particular proceedings rather than litigation generally. Conducting litigation was not simply a question of providing instructions to a lawyer and then sitting back and watching the case unfold. Conducting proceedings was a dynamic, transactional exercise requiring continuous shifting, reactive value judgments and strategic forensic decisions. That was the case, even if the litigant had instructed the best solicitors and best counsel in the business. In proceedings such as the instant one, a litigant had to be mentally equipped, not able to follow what was going on, but also to be able figuratively to tug counsel's gown. A litigant needed the same capacity to conduct litigation, whether they were represented or not. So that is how the law has moved on. And how we can see that the courts are now grappling with this in a practical and sensible way. And I hope those last three cases will provide you with some practical guidance as to how to set about this task. Thank you, and I hope, Susanna, you've been left some time to talk.
Thanks very much, Sean. That was a very interesting run-through of general capacity points. I'm going to, in the time available, firstly talk about the Court of Protection as it fits into personal injury litigation on a practical level, and secondly talk about how a lack of capacity may well add to the quantum of the claim. It's going to be something of a whistle-stop tour because we don't have an awful lot of time left, and I don't want to take up the entire lunch break of everyone who's joined us. Yes, so the first question which comes to the fore is the question of whether the claimant is a protected beneficiary. So you could well have the situation where a claimant is a protected party for the purposes of conducting litigation, but is not a protected beneficiary. So that's the key test. You may well need expert evidence on that point. If they're not a protected beneficiary, then they're entitled to the money straight away if that's what they want, although obviously they might choose to put it in a trust, but that's entirely up to them. So that is the first question which we as lawyers have to ask. And I should say that it's entirely possible that a person lacks capacity for some financial decisions and not others. So, for example, spending small amounts of money day to day, they might have capacity for, but not large complex decisions about how to use the fund. They might be in danger of making very unwise decisions arising from a lack of capacity. And in that case, they do lack capacity. And they would still be regarded as a protected beneficiary. CPR 21.11 sets out the basic framework. The key point here is that money will be dealt with in accordance with directions given by the court under this rule. That's 21.11(1)(b). I should say as well that minors who lack capacity and are likely to lack capacity when they become adults are treated in the same way as protected beneficiaries. That's paragraph 8.3 of the practice direction. You'll have seen this provision before, but effectively, if it's £50,000 or more, and if no one has yet been appointed to authorise P's financial affairs, whether that's an attorney under a registered enduring power of attorney, or a donee of a lasting power of attorney, or a deputy appointed by the Court of Protection, then the order approving the settlement will contain a direction for the litigation friend to apply to the Court of Protection for the appointment of a deputy. If the sum of money or the sum of damages is less than £50,000, it can be dealt with by the judge who is approving the settlement, and that might just be a district judge or a circuit judge given the amount of money involved. The judge has quite a lot of discretion in these circumstances and not a great deal of guidance from the CPR. Guiding principles are always those set out in the Mental Capacity Act, section 1.5 being that a decision must be made in the person's best interests, section 1.6 that a decision should be made to achieve a purpose in a way which is least restrictive of a person's rights and freedom of action. And we have the guidance in section 4 about what best interests means, or rather a process of deciding what's in their best interests. But the judge basically has quite a bit of discretion in what to do. In my experience, what is most common is for the litigation friend to explain to the judge how he or she thinks the money could best be used in the interests of the protected beneficiary, and either for the funds to be paid directly to the litigation friend to be spent in a particular way, or for the funds to go into the court funds office and then be paid out at the request of the litigation friend and under the guidance of the court. The Court of Protection, in terms of the powers it has for investment, if the sum of damages is more than £50,000, of course, it will be dealing with it, assuming there's no deputy or someone else. And the court has the power to make a decision on P's behalf in relation to a matter or to appoint a deputy. And there's a suggestion in subsection 4 that it's preferable for the court to make decisions itself. It says a decision by a court is to be preferred to the appointment of a deputy, but in reality, where there is a significant award of damages, which is going to need to be allocated over a long period of time, the appointment of a deputy is going to be appropriate, as opposed to leaving it to the Court of Protection to decide on specific decisions. This has actually been looked at by the Court of Protection in the case of Watt and ABC. Paragraph 73, it says, in both property and affairs cases and welfare cases, there will be important one-off decisions, and in such cases, the principles and so factors set out in section 16.4 would be likely to point in favour of the Court of Protection making the decisions. But in both, a need to make a number of decisions on a single matter or on a number of day-to-day matters over a long period will often arise that will clearly outweigh the principles identified in section 16.4. In many such cases, regular return to the Court of Protection would be unnecessarily time-consuming, emotionally stressful and expensive, and so contrary to P's best interests. A refusal or reluctance based on section 16.4 to appoint a deputy is not justified. In terms of the deputy, this person or it can also be a corporation, will act as the interface between the court of protection and the claimant and his or her carers, or should I say P's carers. And in the case of a traumatically brain injured individual, the appointment of a deputy may well last a lifetime, and it can be awfully hard work. Technically, a deputy can be a family member or it can be a professional. In high value cases, a professional is probably going to be preferred because of their expertise and in order to remove tensions which might arise if a family member was carrying out their task. There can be more than one deputy, obviously disadvantage being that it would cost that much more. With the Court of Protection's permission, the deputy may be remunerated from the claimant's funds, section 19(7)(b). Deputy must act in accordance with the principles of the Act, so that's particularly sections 1 and 4. And this is a significant point. The deputy does not have power to make a decision on behalf of P if he knows or has reasonable grounds for believing that P has capacity in relation to that matter. So in effect, where, for example, P has fluctuating capacity or capacity in relation to some financial decisions and not others, the deputy is required by the statute to allow P to make those decisions which he has capacity to make. And that is an advantage of the deputyship scheme, that it has that flexibility in adapting to the situation. Sorts of tasks which a deputy may well end up doing entirely depends on the case and the sort of needs that that P has. But for example, liaising with case managers, paying household bills, arranging payment of staff, helping to arrange holidays and funding them, and engaging other professionals as necessary. For example, instructing solicitors to deal with employment issues arising, possibly engaging an estate agent to find a suitable property. Hugely diverse range of tasks which the deputy has. The big two options which the Court of Protection has regarding investment is whether the damages award should be held and administered by a deputy or by trustees of a personal injury trust. And that's simplifying it massively, but that is usually the choice which is being made. So often the solicitors or the litigation friend will propose a trust with particular terms, and then the court will look at that as an alternative to appointing a deputy. Where the Court of Protection authorises that money can be dealt with through a personal injury trust, the need for a deputy will generally fall away. In Watt and ABC, the Court of Protection gave guidance on the decision as to which would be more appropriate. Here, P was awarded £1.5 million brain injury. He had capacity to make decisions about day-to-day affairs, but not capacity to make decisions about the management, investment and application of his award. The court decided that deputyship was appropriate and that this was the more usual way forward, although there was no presumption that it should be appropriate. We are very short of time, so I'm not going to talk through this except to say there is no presumption that there should be a deputy. It's a case of looking at the facts, but having a deputy is more usual, particularly where you have fluctuating capacity. So those are relevant points from Watt. And again, and I'm just going to skip through this, this sets out the reasoning of the court. I suggest that you read this, and also paragraphs 54 and 55 helpfully explain the factors that are to be considered in deciding which was better in these circumstances. And where a personal injury trust is proposed, and where those trustees are connected with the solicitors who are in charge of the litigation, it will need to be established that the solicitor's influence in setting up the trust has not been undue. That's the ratio of the case of OH and Craven. In this case, there were two claimants. One of them was a child, and there was an application that awards of damages be paid out of the Court Funds Office and to the trustees of personal injury trusts. I should say one of the claimants had lacked capacity, was an adult, and then there was a decision that actually they did have capacity to manage the funds. In both cases, the trustees were connected with the solicitors who had conducted the litigation. There was an irrebuttable presumption that a solicitor had influence over his client, and there was a rebuttable evidential presumption that when a large sum of money was vested in the client's solicitor, subject to charging and other powers vested in the solicitor's influence had been undue. Solicitor would need to rebut that presumption, typically by evidence demonstrating that the settler, i.e. the litigation friend, had received independent advice such that he was acting spontaneously in setting up the trust in circumstances which enabled him to weigh matters up and exercise his own free will. So in this case, the court adjourned the child's application for a trust in order that evidence could be put together to see whether the litigation friend had been able to make an independent decision. The adult claimant, who actually did not lack capacity, obviously was able to have that trust set up. Relevance to damages, there are significant additional costs if you've got someone who lacks capacity and therefore needs a lot of assistance in managing the award. Generally speaking, those costs are going to be reasonably incurred where the claimant's lack of capacity is the result of the defendant's negligence. Heads of loss are costs arising from the court of protection, costs of a professional deputy or trustee, depending on how the money is dealt with. So that's going to be a very significant cost, not the cost of any investment advice. So it may well be that it's sensible when you come into £3 million to pay someone for investment advice. But the case of Eagle and Chambers number 2 on the screen, approving the decision of Page and Plymouth Hospitals NHS Trust, found that to allow the cost of investment advice was an impermissible attack on the discount rate, and that the sorts of costs of seeking investment advice were already taken into account in fixing the discount rate. So in other words, not something additional that you could claim, but already baked in to the discount rate when determining future damages for future loss. Likely bones of contention for damages awards. There are going to be plenty of different bones of contention, but the main ones, whether or not P really requires a professional deputy or trustee, whether a professional deputy is needed long-term or just for the first few couple of years. There's a lot to set up in the first few couple of years, so it could be that the need falls away after that. Possibility that P might regain capacity in the future and therefore not need a deputy, so that cost will fall away. And the possibility that the damages award may run out, for example, where you have a claimant who lacks capacity, but there is a significant contributory negligence element such that the damages award is not going to last them. And it may be that at some point, unfortunately, the damages was going to run out. Clearly, at that point, you're not going to need a deputy to manage it. So that's a point defendants might argue. It is now 12:57, so we've got through a lot, and these slides are all going to be available for you, and they will be sent out. Yes, I think we will skip through this because unfortunately we are out of time, but there are more points on there. If you have questions, I'm just having a look to see if there are any questions in the chat. No, there aren't any questions.
There were 3 webinar questions, but they're not, Susanna.
Yes, let me just.
Well, let me just read them out. The first one was, how does the age of the claimant fit into all this? For example, if it was a child with a brain injury. Well, the child, being under the age of 18, will be deemed to lack capacity in any event. So it'd be necessary to appoint a litigation friend if there's to be litigation in relation to the issue in question. And in any event, any settlement that would be arrived at for that child would obviously need the court's approval. That's CPR 21. Anybody else want to add further to that, David?
It also depends on capacity for what, if you see what I mean. We're talking about conducting litigation or participating in litigation, and that's clearly the case as explained by Sean. There are other aspects of, well, how severe is the brain injury? Does the child in due course have capacity to consent to other things? Gilead competence and other such matters. So one has to look at what the capacity is for and at that particular time. And we're just addressing, John just addressed the litigation. There are other aspects of capacity that a child, even a child with some cerebral injury, may well want to consent to or participate in, and they have to be dealt with on the particular facts of that particular circumstance and that particular time.
Susanna, anything else you want to add?
No, I think that was very comprehensive.
Right. The next question was how to proceed with child injuries with mother. That's quite cryptic, but I deduce from that that it's a question of what the mother's involvement would be in the claim brought by the child. Well, the answer to that, I would suggest, is that if she's a suitable person, then she would be an appropriate individual to be appointed as a litigation friend. And that litigation friend would then conduct the proceedings on behalf of her child and be responsible for reaching the decisions that need to be made during the course of the litigation in conjunction with the instructing solicitor and, if needs be, in conference with counsel. David?
She also has to be given the direction, just because she's mother doesn't make it any difference to you or I, about the rights and responsibilities of a litigation friend. And that's part of the preparedness before you sign up to be a litigation friend. The other thing, as far as mother or parents participating in litigation, it's often seen that they become one of the trustees for the personal injury trust, along with a professional trustee. And that depends on the particular circumstances. It depends on the level of comprehension and involvement of that parent or mother. But that's another phase of involvement that's different to being a litigation friend.
The next question was where P requires a deputy to manage their settlement. In practice, how do litigators go about this? Refer to COP team/ask court. Susanna, would you like to go first on that?
Well, they have to make an application to the Court of Protection. And obviously it's dealt with differently in different solicitors' firms, but ultimately the Court of Protection is responsible for appointing a deputy. And it's fairly straightforward to make an application to the Court of Protection. If it's a big High Court case, often you can find a High Court judge who also acts as a Court of Protection judge to deal with it.
David?
Yeah, I mean, obviously it depends how a firm's particularly set up. In my view, for most high-value circumstances, I think a deputy should be somebody very much at arm's length, and there must be another firm, be it locally or nationally, that one could refer work to for appointment of a deputy, and vice versa. But as Sean has explained, that the presumption is that a solicitor has influence over their client, and if anything in the relationship between the injured or protected person, or child, and anybody else, such as a parent or anybody else like that, or even anything that's indicating that there is tension within that, my view is that the solicitor should be very careful to appoint a deputy that's at arm's length.
The final question was, in a claim involving an adult with capacity, is it possible to successfully recover the costs of a professional trustee? I think I know the answer, but Susanna, would you like to go first?
Yes, you definitely can. One of the key elements. And you'll need evidence, obviously, as to the cost, and the cost can be very substantial.
David?
Sorry, Sean, I was just looking at the question that's come up. If you could just deal with that in a minute, and I'll bring forward the question that we've just put on the chat.
Right. In a claim involving an adult with capacity, is it possible to successfully recover the costs of a professional trustee? I'd suggest that if the individual has capacity, then that's one of those problems that you will face, that you will need to persuade the court that there's a basis for appointing the deputy, and if you haven't, well, then it'll be regarded as one of those investment costs that are resulting from the decision to accept a very substantial sum of money, and will be treated in much the same way as the costs associated with seeking investment advice in relation to your damages award when you do have capacity, which, as Susanna's already indicated to you, because of the decision in Egan and Chambers, is not recoverable because it's a sidewind attack on the discount rate.
I'd agree with that. There's a question in the chat. If someone brings forward a different case regarding a different claim, for example, a personal injury case, but they have had a TBI in the past, would they still need to be considered when assessing their capacity? So does a person ever really recover from a TBI, or should it always be considered not just in their specific TBI case, but in all future legal matters? I mean, my view would be yes, if you have traumatic brain injury, depending on what the particular matter that you're asked to have capacity for or not. Let's say it's another legal claim, let's say about your house or something similar rather than to do with your personal injury, then subject to the particular facts of that particular claim. If you are somebody that had previously been a protected person that lacks capacity to litigate in your own TBI claim, then I think the starting point would be, I need persuading that you've got capacity for dealing with your property claim or anything similar. Though, again, it's the capacity and the particular circumstance at that particular time. So, but in general terms, that would be my starting point. You lack capacity.
Yes, well, I think this is something that has arisen in the past, and indeed the case of Marston and Lister was all about this. Not in relation to a subsequent claim, but what happened was the individual in question later decided that they wished to challenge the settlement that he had received. He then sought to argue that he lacked capacity at the time in question. And that was an issue which contested at first instance, and as you know, in the Court of Appeal as well. So if the individual lacked capacity at the time the settlement was reached, then the remaining question is not, can you unscramble that? The answer is yes, you can. The question is whether or not it's worth doing so, because the individual may, of course, have received a perfectly adequate settlement award in the first instance, in which case your complaint is about process rather than substance. If the settlement has been at undervalue, well, then there is an opportunity, subject to limitation questions, for the individual to apply to the court to have that original settlement set aside. And this is the very reason why insurers, even if they want to contest whether or not the individual has lost capacity, but where there has been a dispute between the parties about that, go before the court in conjunction with the claimant and ask for the court to approve the settlement, so that without deciding the issue, did he or did he not lack capacity, the court looks at it under CPR 21 and decides that it would be in the individual's best interest to accept the settlement offer that has been made by the defendant, and approves that settlement. But what that does is give the claimant the comfort of knowing that somebody independent, namely the judge, has looked at the settlement offer and considers that it is an appropriate amount for that individual to accept, that it's in his best interest to accept that sum. Secondly, it gives his own solicitors protection, because the court will have approved that sum, and therefore it will be very difficult after the event to suggest that they have allowed him to undersettle his claim. And thirdly, so far as the insurer is concerned, it's valuable to the insurer because it means they get good receipt for the sum of money that they're going to pay over to the claimant in compensation for the claim that's been advanced.
Finally, there's one question from Amy Edwards, final question. Presumably if a TBI claimant obtains a second TBI, which worsens their position, they would have a claim for anything that is caused as a result of the second TBI over and above the first, i.e. the additional costs of deputyship, etc.
This can arise. It's a causation issue, isn't it, at the end of the day, because it'd be incumbent upon the claimant to establish that the second TBI has worsened his position, both as regards general damages and then as regards financial losses, which may include additional care costs, because he now needs 24/7, whereas before it was, a couple of hours during weekdays. And there may be other financial losses that you could establish have resulted if the person's gone back to work, but not at the same level as prior to the accident. Then he has a second one and he's unable to work at all. Then again, there'll be a financial loss differential that could be recovered. But at all times, it's the added loss that flows from the second TBI, and that alone which would be recoverable in a second claim.
There's bound to be some challenges about prognosis as well, about what over time would have been the circumstance and the needs as set out in the first bit of litigation, as against what would happen over time because of the second TBI. So it's the sort of thing that's going to need careful prognostic evidence and careful consideration about on what basis the first TBI was settled and the damages that were awarded.
Susanna, anything else you wanted to add?
No, I think that's really, really comprehensive. Good question, though.
Yeah, I think that's it as far as the questions are concerned. I'll just check to make sure. Yeah.
But if anything occurs to someone, then do please drop one or all of us an email, and I'm sure we'll be able to help.
Well, can I round up by thanking you all for attending and for staying on after the appointed hour had expired. I think you can see why we ran our full hour or very close to it with our talks. I hope you found them not only comprehensible, not only comprehensive, but in addition that you found them helpful in a practical way, which is the objective that we had when we prepared these papers. As Susanna has said, please feel free to write into us with any queries arising out of what we've said, or indeed anything associated with the talks that we've given. Thank you very much for your time.